Hi, guys. My name is Alina Shautsova. I'm an immigration attorney from New York. And today we're having our live session to talk about immigration and the latest news. I'm going to talk about the latest news from Texas federal court that is affecting all those who are in immigration court proceedings, rather will be waiting, perhaps maybe if apprehended to be in immigration court, basically people without status, because the judge just ruled on enforcement priorities memo for ICE. I'm going to talk about those who are filing for green cards, what good news we have, and I'm going to talk about some other recent changes. Some good news from Nevada, also by a federal judge. So thank you very much for joining me. Please say hi, comment on where you're watching me from. Hi, Angelica. Hi, Magdin. And thank you for joining me again. And we're going to start. Well, first of all, we have bad news and good news. And I'm going to start with the bad ones. I'm going to start with the bad ones to get over with those news. Hi, Yannick. Hi, Nizla. Hi, Prisha. So what happened today is that a Texas judge, federal judge from Texas, always in Texas, guys, issued another decision that undermines Biden's plans on reform of immigration system. I would call it like that. What happened is that if you remember, if you are following immigration news, at the beginning of the year, right after Biden took office, his administration and DHS, basically ICE, issued a couple of memos about the enforcement priorities. Basically, who ICE is going to be detaining and removing in case they encounter the people, basically without documents, without status. And according to the Biden's priorities or Biden's administration priorities, they would pretty much leave everybody as is unless a person poses danger to public safety, national security, and even if they committed an aggravated felony, the person will not be removed unless they also pose those dangers. And immigration officers would first have to determine if the person would pose such a danger prior to removing them. And they would have to check with their supervisor as to what to do with a person if they encounter such a person. But everybody else, basically, if a person just happened to be without status, maybe they overstayed their visa, maybe they crossed without authorization across the border, absent criminal activity of some sort, and this security concerns, they would not be detained and would not be removed, just so that ICE can focus on priorities that actually matter and would make the system of removal is more fair and effective. But of course, some people were not happy about that, especially people in Texas. And the state of Texas sued the Biden administration in court. And of course, it happened in federal court in Texas. And after a couple of months of litigation, basically, the federal judge ruled that the new enforcement priorities that were issued by the Biden administration are unlawful, or so probably will be. It's called preliminary injunction, where the state of Texas, according to the judge, was able to show that more harm than good is going to come out of these enforcement priorities, and that the enforcement priorities that Biden administration put in place were against the law. Never mind that they were placed by the current administration, never mind that they changed the Trump administration's enforcement priorities that in turn came in place after Obama's enforcement priorities. If you remember, during the Obama, we had something called prosecutorial discretion and so on, when ICE officers also would usually cut you a slack if you're not a violent criminal. And then when Trump came to the office, they reversed that and stated, we're going to remove anybody we see. It doesn't matter. You're illegal here, you're going to be out. Biden administration came and said, wait a second, we cannot just try to remove and round up anybody. There are millions of people. Why don't we focus on our efforts on somebody who's actually dangerous, presents concerns to the public safety and national security, which is probably a rational approach. Not for some people. Hence this today's decision. Decision came in a lawsuit, Texas versus United States, docket number, if I'm not mistaken, 621-00016 from the Southern District of Texas. So what's going to happen now is this. The judge ordered that the government, ICE, cannot anymore, unless a higher court is going to change that, higher federal court is going to change that, cannot use the Biden's administration memo in doing their work. They will have to also keep reports of everybody they encounter. And by September 3rd, they will have to report to court how many people they encounter that they didn't put in removal. And they will have to put those monthly reports before the court to show that they are actually removing people. And I'm sorry, by September 3rd, they have to present to court the legal standard under which they're operating. Basically, the government will have to state they're no longer using those memos in writing before the court. Why? It's because then ICE officers will not be able to legally act on those memos, and that what immigration lawyers would be advising to their clients, basically saying that, listen, now everything goes. We're going back to that time when that ICE enforcement priorities that were implemented by the Biden administration are no longer in place. All right, so that's what's happening. I mean, of course, it's disturbing because it undermines Biden's efforts in bettering, improving immigration system in the United States. The good thing that probably there will be an appeal. It's going to take some time, and of course, there is always risk that the higher court will sustain the decision by the lower court, but hopefully it will not happen. So this is where we stand now. So that stop on deportations that we had and the stop on enforcement in general is now reversed. And you can see that in the United States, it's never can be for granted. Even if the administration is trying to make some changes, there are federal courts that may side with their position. We saw that in DACA cases where DACA was ordered illegal. We saw that in, for example, just another recent decision where Remain in Mexico protocol was ordered to be followed by the Biden administration, the protocol that he tried to eliminate. And now we have this ICE enforcement as well. So we're going to see what's going to happen. Hopefully, the appellate court is going to disagree with the lower judge, but of course it's going to take time. And in the meantime, as always, we are in quite a mess. Wow. So we're going to now proceed with the good news, right? Good news. We deserve some good news here. The good news for those who are filing for green cards, and for many applicants for green cards, almost for everybody, applicants will have to submit medical exam. Well, I call it green card medical exam. Somebody calls it some other name. But basically, those medical exams are constantly expiring in the process. And maybe you experienced it yourself, that you would receive the deficiency notice in the middle of your case being pending, where USCIS will ask you either to come in and bring your medical exam because it's expired or somehow invalid, or they will ask you to mail it to them. So because of this COVID situation and this unnecessary delays with this medical exam situations, current administration also made a decision to extend the validity of medical exams for 4 years now. But there are some limitations. For this exception to be useful to you, you have to already have a pending case pretty much. And the medical exam signature on the medical exam was supposed to be no older than 60 days at the time of its submission, and the doctor's signature the exam itself should not be older than 4 years if the decision on the case is made prior to September 30th, 2021. So basically, they gave us like this months and a half window to use this exception. We're going to see. Maybe it will be, if I'm not mistaken, this is the only time, but maybe we'll see that it's going to be extended, because honestly, medical exam just tests you for your vaccines, right? And we're not talking about the COVID vaccine, we're talking about other vaccines. And pretty much those are vaccines that you get once in your life. So why it's constantly expiring, this exam, I have no idea, but it's a constant hustle with that. So this is the good news, because it may make someone's life a little bit easier. And now the best news ever. A federal judge in Nevada just ruled that a section of federal law that criminalizes illegal entry and re-entry is illegal, okay? That it was discriminatory and should not be longer applied. And it's a big deal, because many immigrants were suffering from those criminal consequences of illegal entry when they were charged with criminal entry or re-entry. And I think I read that about 30,000 such cases were brought by the federal government last year. 2019, I believe. So it's a huge amount of people who were affected by this law and policy. It's a old law, I would say, what, half a century at least, right? But the problem was that during the certain administrations, it would not even be used. But during the Trump administration, he specifically said to use that law, and hence many people were convicted, right? Convicted of misdemeanors and felonies. And now the judge ruled that the law was discriminatory in its core and it shouldn't be enforceable. So it may be a good news. Maybe some of you or somebody you know may benefit from it. And of course, we do not know what will be the final decision. Maybe there will also be an appeal, because everything goes like this. There is a decision by a district judge in federal court, and then one of the parties can appeal this decision to a higher court, federal court. And then, of course, there is a US Supreme Court that always has the final word if the case travels that far. So we have good news and bad news. I'm a little bit concerned about this enforcement priority, just because it stresses people out usually when they hear that they can be picked up and deported. And we're going to see what's going to happen. Hopefully the government is going to file the appeal pretty quickly, and the higher court is going to rule that those enforcement priorities that Biden administration put in place should stay. Now, if you guys have some questions, I'll be happy to answer them. Let me see. Hi, Marie. Hi, Yannick. Florida, yay. It's probably very hot, right? But New York is no cooler right now. Hi, Jay. Nevada. Hi, Atis. Jamaica. Hi, Gafris. Hi, Gender. And I'm sorry if I mispronounce your name. Like, my name is easy to pronounce. Hi, Ahmed. Thank you very much. Hi, Ronnie. Hi, Kareem. Trinidad and Tobago. I would love to go there. The pictures look beautiful from Trinidad and Tobago. Hi, Sukhinder. I have a pending withholding of removal and pending U visa with 2 years. When I can get a work permit? Well, if you have just a pending withholding of removal, based on that, usually I do not think you will qualify for one, because you're not a person pending for asylum. You may qualify under a different category depending on your situation. Maybe you were granted what's called by ICE, you were granted an order of supervision, so perhaps you can check with your attorney if you can get a work permit based on that. But for the U visa, guys, to be able to apply for the work permit under the new rules, you have to get a special notification by USCIS. They stated that they will review all the cases, and if they find that your case was filed in good faith, they will send you this notice that now you can file for the work permit. Okay, it's not automatic. You basically have to file for it. Hi, Didi. Hi, Mulu. Hi, Valerio. Good day. I had a master hearing, but it was canceled. And the lawyer said that there were no longer master hearings. The lawyer may be correct. What happened is this: immigration courts adopted a new memo saying that if you have an attorney and your lawyer files a notice of appearance 15 days prior to your master hearing, your master hearing should be canceled and you're going to receive a scheduling order instead. A court is going to give you deadlines as to when you're supposed to file your documents, pleadings, and so on. Unfortunately, sometimes it doesn't work. You still have to come into court. I do not know, maybe because of some processing delays in court. So you always have to check the calendar and see. And you can check, by the way, as a person, you can check your calendar by Googling EOIR online or automatic status, and you're going to punch in your A number and you will see if there is a future hearing date for you. Okay? Don't just rely on the court to do the thing that they promised, because I just had a case when it didn't happen. And we actually have to go to court with a client, even though they were supposed to cancel his hearing, but they didn't. So you have to watch out. Hi, Ignacio. Will administration overturn, or will they overturn the decision by the Texas judge? It will be decided by the higher court. Administration is a different branch of the government. They cannot change court's decisions. So it's only the higher court that now will have control over the situation. We'll see. Hi, Garbus. Any thoughts about Mavni? Honestly, have not had any updates, guys, regarding Mavni. I know that during the Trump administration, they effectively stopped processing requests under Mavni, but I'm not sure if it changed. Have not received this year any news about that yet. Hi, Ray. Trying to book an appointment with you this Saturday. You can call my office and see if I have any spots available. It's 917-885-2261. My number, my office. Hi, Coyote. Hi, Alina. I do motion to reopen I-45 denial and I-130 over 6 months. I haven't hear anything. How long should I wait before I can get response? Sometimes it takes a long time, guys. Sometimes it takes literally a couple of months, and sometimes it takes a very long time. I can tell you that you can look at the processing times for Form I-290B. But, what if your case is pending past processing times? What recourse will you have? Not much, I'm going to tell you right now. But genuinely speaking, such motions can be pending for a very long time. I will not be surprised if it's going to be pending for over a year. Depending on the reasons for the denial, hopefully, maybe you just missed an interview and that's why you were denied. It wasn't something that goes to the core of your adjustment of status eligibility. And in that situation, hopefully they should basically now issue a decision on your case. If you'd like to, you can try to go with a congressman, call them up and say that you need help with your immigration case. They're usually very, very helpful, depending on your state, of course, In New York, the senators from New York are very helpful in assisting people with immigration cases. But they usually look at also processing times. And if your case is still within processing times that are posted on USCIS website, they're going to say, well, they need time to decide. And unfortunately, we're still experiencing huge delays. Hello. Any TPS update? Oh, well, yeah, depending on for which country. Haiti can file for TPS. Some other countries were redesignated and designated. So if you have any TPS news, you would like to get any TPS news, you can go to uscis.gov website and search for TPS, and it's going to take you to a very good, resourceful page that lists all the countries that were designated for TPS with the dates of when they were designated. It's very important. And when they were redesignated, it's very important. Redesignated means that those people who were in the United States and missed the first time filing now can file again. Now can file for the first time. It's basically as if it's designated for the first time. But those people who already had status, TPS status, and now their country, like with Haiti, is redesignated, they should also file the applications as well, not to have a gap in their status. Hi, Elvis. Nobody's talking about the Olympic Games medals. Half of them are won by people that immigrated to the country and represented USA in Tokyo. How about that? I don't know. I'm an immigration lawyer, but if you're talking about the fact that immigrants are contributing to the success of the United States on the international arena, that's a fact. And many people do talk about that. I mean, you're absolutely correct that some talented athletes, coaches as well, by the way, receive status, green cards in the United States and citizenship. You know, many people do say that immigrants contribute a lot. And also, if you follow the news about the recent census, like the makeup of the population of the United States, it seems that United States will need fresh blood and fresh hands to sustain its population. So immigrants are essential. I'm just not sure what their position's view on that it is and why they're constantly resisting passing immigration reform, but the future will prove itself. Hi, Alina. Is Opla attorney PD blocked today or not for immigration court cases? We're talking just about ICE, guys. We're talking about ICE enforcement priorities. Okay, that's my understanding. That's my understanding what the court ruled on. What happened to immigration for essential workers? So far, nothing happened. After the Senate passed the budget reconciliation provision, what's going to happen is that the law has to be drafted, it has to be adopted, it has to travel through the House of Representatives, and yes, there are some problems there in terms of one side says we're going to pass it only if it includes everything we want. And it's a problem for me, and I keep talking about it in my videos because I feel that they should take anything they can, but we'll see where it's going to go. So far, nothing. And the votes and everything are going to be, I think they have what they call soft deadline, September 15th, if I'm not mistaken. So hang on there a little bit more and we will know more information about what's going to happen. Hi, Giwa. Can someone file for his wife from Africa with permanent resident green card? Yes, of course you can. As long as you guys have a real marriage, you can start the process by filing alien relative petition. Absolutely. Hi, Jewel. Thank you for watching. Hi, Ahmed. Hi, Titans. Immigration reform feels impossible. It does, right? Until it happens. So I think it is very possible. I don't think they will agree on comprehensive immigration reform, but I think if they play their cards right, they will be able to pass something for somebody. Definitely, probably for Dreamers, guys. I have a feeling that group will be addressed just because senators from the Republican side themselves were offering some proposals which now don't look that bad, right? Several years down the road, they're like, oh, why didn't we take that? So I think Dreamers will definitely catch a break. I'm not sure about other groups. Hi, Solo. Thank you very much for thanking me. Thank you. So sweet. Hi, Sergio. If immigration reform passes and we get pathway or TPS, would we be able to get some kind of travel document to pass border and come back? Yes. With a TPS, it's a temporary protected status. Temporary protected status is not an immigration reform by itself. A country has to be designated for it. For example, it happened for Haiti, for Venezuela, for El Salvador, some other countries in the past. It's probably going to happen, or at least should happen, for Afghanistan. That's my position. Maybe the government has some other position. But somebody who has TPS can file for and receive advance parole that allows them to travel back and forth. Immigration reform, that would be a path to green card first, usually, right? You cannot become a citizen without being a green card holder first. And the proposals that I read state that, yes, there will be authorization to travel. And otherwise, it doesn't make any sense, right? It's like if you have this temporary status and cannot travel, it's like you're being hostage here or something. So no, there will be opportunity to travel if it passes. Hi, Chioma. I'm in removal proceedings. Is it safe to travel with America with my country's valid passport? No, no. If you're in removal proceedings, you should not be traveling. No. So, can we still apply for PD or has it been stopped as well? My understanding that PD has not been stopped. My understanding is what was stopped is ICE discretion on whether to arrest somebody if they encounter them and the person does not have a legal status here, and remove or not remove, issue notice to appear or not. That's what we're talking about. Okay, that's what my understanding of this order that came out today, because the order also says the reporting requirements, and all reportings are focusing on how many people did you encounter and didn't detain them, why you didn't detain them. The government will have to send these judges reports now. It's like, I don't know if they will be able to do it, but that's what they've been asked. All right. Hi, Kum. Alina, I have a question regarding backlog in Chicago Immigration Court. Do you have any info about that? Guys, do not have any information about Chicago Immigration Court specifically, but many courts are backlogged, all of them. I think there was information that 500,000 cases, 500,000 cases are in immigration courts, if I'm not mistaken. And I think since then it just rocketed. So I don't think Chicago will be specifically different from any other immigration court, to be honest with you. But I may be wrong. I practice mostly in New York courts. And, the court's been reopened. As I said, they haven't quite perfected the COVID-related memorandum that they issued in terms of canceling the master hearings and so on and so forth. And some judges still require you to appear in person. They say, if you would like to appear telephonically, you have to file a motion and attach your medical records. So, I don't know. So, I better stop talking about it, not to get myself in a lot of trouble. Hi, Ahmed. Would you please help me understand why my decision is late? I do not know, Ahmed. I'm not sure what you filed for. If you can give me a little bit more information, maybe I'll be able to help you. Hi, Asanobi. Hello, Tony. Please, my case is pending with immigration court already. Have a work permit. Will I still benefit from the reconciliation bill for essential workers? Great question. Many people ask me, if I'm already in removal proceedings, if reform passes, will I be able to benefit from it? The answer should be yes. You should be able to benefit from it as long as you're going to be in the United States. In fact, some of the proposals that I saw specifically say that if you had a previous order of removal and you're still in the United States, you will be able to use that essential workers reform that they're going to pass. You will still be able to apply for it. But also, if you are in removal proceedings, your case is pending, and you have not been ordered removed yet, it means that you will be able to ask the judge to stop the removal and allow you to apply for this new reform relief that they're going to pass. So you should be able to, of course, if you meet other requirements, right? Other requirements that you have a special occupation, you have to get an attestation from an employer proving that you work during COVID times as an essential worker, and you pass background checks, all right? So listen, guys, thank you very much for joining me today, and thank you for asking questions. I hope I answered at least some of them and it was helpful. Please subscribe to my channel for more lives and when you can ask your little questions for free. I'm always happy to do that. I, by the way, do the same on my Facebook page, Immigration Lawyer and Why. That's how you can find me on Facebook. And stay healthy, stay safe. Hopefully we're going to have positive news next time when I join you and you join me. And please like, share this video. and I hope to see you soon.